Tonight, a legal battle is brewing, one that has the potential to shape the very fabric of American life for generations to come. The nation's highest court stands at the center of a storm as justices prepare to weigh in on a question that has divided communities, lawmakers, and families across the country. This is not just another case. It's a pivotal moment that could redefine American society and the rights of its citizens. The outcome will echo from bustling city streets to quiet rural towns, touching every corner of the nation. At the heart of the controversy lies a single, powerful issue: the future of assault weapon bans in the United States. These firearms, often at the center of heated debate, have become symbols of both liberty and danger. The Supreme Court is edging ever closer to a decisive ruling, one that could either uphold or dismantle restrictions on these weapons. The stakes could not be higher. This is more than a legal debate. It's a clash of values, beliefs, and visions for America's future. It's about constitutional rights, public safety, and the very identity of the nation. For millions of Americans, these firearms represent cherished freedoms and a way of life protected by the Second Amendment. They see any restriction as a threat to their rights and personal security. Yet, for millions more, these same weapons are seen as instruments of tragedy, symbols of violence that have taken too many lives. They demand action, hoping for laws that will prevent future heartbreak. The court's decision will directly impact not only state laws and law enforcement, but also the daily lives of ordinary Americans. Police, lawmakers, and citizens alike are watching closely, knowing that the outcome could change the rules overnight. As of January 6, 2026, the legal world is holding its breath, waiting for the Supreme Court to step in and provide clarity where confusion now reigns. The debate over gun control is ever present in American life, reigniting with every new tragedy, every legislative proposal, and every court challenge. It's a conversation that refuses to fade, fueled by passion and pain on both sides. Now the focus shifts from state houses and city councils to the Supreme Court's marble halls, where the nation's most powerful legal minds will decide the future. The justices are signaling their readiness to resolve the chaos and conflicting rulings in lower courts, aiming to set a clear path forward for the entire country. What they decide in the coming months could set a new national standard for firearm regulation, affecting not just laws, but the lives and safety of millions. The story begins now, with a court poised to make history, a decision that will be remembered, debated, and felt for years to come. To truly understand today's heated debate over assault weapons, we must look back at the events and decisions that shaped the conversation. The story of assault weapon bans in America is one of shifting public opinion, political battles, and evolving legal interpretations. The national conversation around assault weapons began to surge in the late 1980s and early 1990s. This was a period marked by a noticeable rise in violent crime and a series of high-profile mass shootings that shocked the nation. News reports and images of these tragedies dominated headlines, fueling public concern and calls for action. In response, Congress took a historic step in 1994 by passing the federal assault weapons ban. This law prohibited the manufacture and sale of certain semi-automatic firearms, defined as assault weapons, as well as large-capacity magazines. The ban was controversial from the start, with supporters arguing it would save lives, while opponents claimed it infringed on constitutional rights. The ban was always intended as a temporary measure, set to expire after 10 years. In 2004, Congress allowed the law to lapse, choosing not to renew it after intense lobbying and debate. This decision reignited the national conversation and left the future of assault weapon regulation uncertain. With no federal ban in place, authority over assault weapon regulation shifted to the states. This created a patchwork of laws across the country, with each state deciding its own approach to gun control. States like California, New York, and Maryland responded by enacting some of the strictest assault weapon bans in the nation. Meanwhile, many other states imposed few or no restrictions, reflecting deep divisions in public opinion and political priorities. Today, 10 states and the District of Columbia have laws that ban certain types of assault weapons. These states represent a significant portion of the population and have become focal points in the ongoing debate over gun control. These states are now the main battlegrounds in the legal fight over gun control. Protests, rallies, and court cases have become common as advocates and opponents clash over the future of these laws. Gun rights groups have mounted legal challenges to these bans, arguing that they violate the Second Amendment right to bear arms. Their lawsuits have sparked heated debates in courtrooms and communities across the country. As these cases have made their way through the courts, conflicting rulings have emerged. Some judges have upheld the bans, while others have struck them down, deepening the legal and political divide over the issue. Now the stage is set for the U.S. Supreme Court to step in and resolve this national disagreement once and for all. The court's decision will have far-reaching consequences for gun laws and the rights of Americans. The outcome of this legal battle will shape the future of gun laws in the United States for years to come, influencing not only policy, but also the lives and safety of millions of Americans. Washington State is now at the center of the fight. In 2023, lawmakers banned the sale, manufacture, and import of assault weapons. The law doesn't confiscate existing weapons, but blocks new sales. Gun rights groups, led by the Silent Majority Foundation, immediately sued, calling the ban unconstitutional. The state argues these are weapons of war, not meant for civilian self-defense. Opponents counter that rifles like the AR-15 are among the most popular in America and protected by the Second Amendment. Courts have so far upheld the ban, but only as a preliminary measure. The core constitutional questions remain unresolved. Appeals are ongoing, making Washington's law a key test case. The outcome could force the Supreme Court to decide the fate of similar laws nationwide. The Supreme Court has watched these legal battles unfold from a distance, observing the growing tension and public debate over gun control in America. While the justices have not yet taken direct action, their recent decisions, or lack thereof, are sending a message that is hard to ignore. In late 2025, the court made headlines by declining to hear challenges to controversial assault weapon bans in Maryland and Illinois. These cases had drawn national attention, with both sides hoping for a definitive ruling from the highest court in the land. By refusing to take up the cases, the Supreme Court allowed the state bans to remain in effect, at least for now. This was seen as a significant, if temporary, victory for gun control advocates, who celebrated the decision as a step forward in their ongoing fight to reduce gun violence. However, the court's silence should not be mistaken for agreement with the bans. Instead, it appears to be a calculated move, a strategic pause rather than an endorsement of the laws themselves. Conservative justices, most notably Clarence Thomas, have not hidden their frustration. They argue that the court has a duty to address these pressing constitutional questions now, rather than waiting for a more convenient moment. In a strongly worded opinion, Thomas called the court's delay an abdication of responsibility, warning that millions of Americans are left in a state of legal uncertainty, unsure of their rights and the future of gun ownership. The forceful language from the conservative wing of the court signals a growing impatience and a readiness to issue a decisive ruling when the opportunity arises. For gun rights supporters, this is seen as a promise, a sign that the court is simply waiting for the right case, one that will allow them to address the issue head-on and potentially reshape the nation's gun laws. The refusal to hear these cases is not the end of the story. Instead, it feels like the calm before the storm, a moment of quiet before a potentially seismic shift in American law and society. Behind closed doors, the justices are preparing, reviewing legal arguments, and waiting for the right case to arrive, one that could finally force the Supreme Court to take a stand and shape the future of gun rights in America. The conservative justices' opinions reveal the likely future of assault weapon bans. Justice Clarence Thomas insists the Second Amendment protects firearms in common use, like the AR-15. He argues bans are plainly unconstitutional and urges the court to act. Justices Alito and Gorsuch have echoed this call, ready to rule on the issue. Justice Kavanaugh, while agreeing to wait, expressed doubts about the ban's constitutionality. With at least 4 justices signaling opposition, a majority ruling against bans seems likely. States with bans are now on high alert. The question is not if, but when, the court will make a transformative ruling. The 2022 Supreme Court decision in New York State Rifle and Pistol Association v. Bruen changed everything. The court set a new standard: gun laws must align with the nation's historical tradition. Judges now act as historians, searching for centuries-old parallels to modern laws. This has led to confusion and conflicting rulings on similar laws nationwide. Bruin has energized gun rights advocates, fueling lawsuits against a range of gun regulations. Supporters of gun control argue the new standard makes it nearly impossible to address modern gun violence. The legal landscape is chaotic, and all eyes are on the Supreme Court for clarity. The stakes have never been higher. A Supreme Court decision ending assault weapon bans would send shockwaves through the nation. Politically, it would be a huge win for gun rights advocates and a blow to gun control supporters. States might try new regulations, sparking more legal battles. Gun rights would become a central issue in elections. In states with bans, the firearms market would change overnight. Gun rights supporters would celebrate. Others would feel increased anxiety. Firearm manufacturers could see profits soar, but there may be economic costs tied to gun violence. The ruling would deepen cultural and legal divides. Federal law could clash with the will of millions in some states. The debate would only intensify, entering a new, contentious chapter. Legal experts are deeply divided on the Supreme Court's path. Some argue bans are unconstitutional, as they target weapons in common use. They say the government's role is to punish misuse, not ban popular arms. Others insist bans are both constitutional and necessary for public safety. They argue history allowed regulation of dangerous weapons, and today's assault weapons fit that category. Data shows these firearms cause more deaths in mass shootings. The state, they say, has a compelling interest in protecting lives. The court must balance individual rights with public safety in the modern era. America stands at a pivotal moment. The Supreme Court's decision will define the balance between liberty and security for a generation. Striking down bans would expand gun rights, but limit states' ability to address mass violence. Upholding bans would preserve state power, but anger millions who see it as a rights violation. The debate won't end. These are moral and civic questions for every American. The answers will shape the nation's future. The story is still unfolding, demanding reflection and engagement. The challenge is to navigate deep divisions with respect and a shared commitment to a safer, freer nation.